I've prepared a training focused on the legal concepts that apply to the redistricting job itself, and that therefore apply to the work of the commissioners that you are about to select. In doing that, I'm not going to focus on the explicit conflict of interest criteria that are laid out in the Constitution, that are laid out in California Government Code, that are laid out in regulations, not least because those you've had training on, you will have training on. There's additional clarity provided by the regulations themselves about who might have a conflict of interest and what counts as an eligibility to join the commission. Instead, my task, as I understand it, is to help you understand the job of redistricting itself and the laws that govern redistricting in California, so that you'll know some of the softer factors you've been asked to consider. The ability to be impartial, the ability to be analytical, the ability to do the job beyond conflicts of interest that will help you select the most qualified applicants for the job. That is, I take my task as describing the substantive task of the Citizens Redistricting Commission that will assist you in understanding the traits that you may be looking for, or the traits that you may want to select for in choosing the pool of commissioners themselves, or the potential commissioners. I've got several hours. I will try and take us till noon and certainly not beyond. I've also built in time for questions. There are discrete units. Please interrupt me if you have questions before I specifically stop and ask for them, but there will also be periods when I'll stop and ask and make sure that everything that I've said is clear. And with that, with your permission, so just to let you know briefly, I've had the privilege of working in redistricting and both analyzing and assisting the redistricting process for about 15 years now. I have had the privilege of working in the state context and the federal context. I have advocated in this sphere. I've studied in this sphere. I've had the opportunity to enforce federal law in this sphere. Perhaps of most interest, I had the wonderful opportunity to help train your predecessors 10 years ago, and I am absolutely delighted to be back. This is among the most impact that I can have in actually driving the shape of a state's lines as its citizens prefer, as they've set out in the law, and so I'm delighted to be here in that capacity. As mentioned, I'm going to focus today on the laws that the commissioners will need to apply to let you assess the traits that you may be looking for in the pool of potential commissioners. This presentation is going to be specific to the laws that govern California's districts. So California has a few rules and regulations for the redistricting process that are not, some of the rules are common to the rest of the country. Some are very specific to California. And I've focused only on the laws and regulations that the California Redistricting Commission will be asked to apply by federal law and by California state law. This Redistricting Commission is tasked with drawing congressional lines and lines for state legislature, lines for the Board of Equalization. And so I'm not going to address different rules that apply to local district lines in California because the California Citizens Redistricting Commission isn't tasked with drawing those lines. I'm going to try to lay out legal requirements and concepts and hopefully do it without legal jargon. But that's where I'm counting on you to stop me if you have any questions whatsoever. And I'm constraining myself, although I've operated in a few capacities. I'm currently a professor at Loyola Law School, and it's in faculty professorial mode that I'm here before you today. I'm going to be laying out the requirements of California law without, I hope, without any advocacy, letting you know what flexibility the commissioners have, what flexibility they don't have, letting you know where the past commission succeeded and where it ran into some struggles. And hopefully it will be a balanced and neutral presentation simply of what the requirements are on the individuals that you're going to put into a selection pool. The real legal hook for this whole presentation is that you are tasked with choosing individuals with relevant analytical skills. That's a quote directly from the regulations of the individuals you are to screen into the pool. And with luck, this presentation and this training will help flesh out what those relevant analytical skills are. What are the commissioners going to need to do? Therefore, what traits should they have that will let them best tackle that task? And I like, when I can, to distill the basic questions into those a fourth or fifth grader can readily identify. Some basic W questions. Why do we do this? Where are the lines to be drawn? What are the commissioners going to actually do in terms of their day-to-day tasks? When does all of this have to get done? I'm not going to speak to who. That's your job. So to start in, why do we do redistricting? What is the impetus for redistricting? Why do the commissioners have to engage in this project at all? Redistricting is the act of drawing and redrawing the lines that determine which voters are represented by each legislative seat. And the reason for redrawing is that when you have any jurisdiction, but certainly a state as large and diverse as California, you see naturally over time communities growing and shrinking. People are born, they pass away, they move, and areas where there once were roughly the same number of people become, over time, lopsided as the population shifts in ways that are not uniform across the entire state. In a series of cases, beginning with a Supreme Court case called Baker versus Carr in 1962, the US Supreme Court determined that district lines used to represent people in electoral seats, Congress and state legislature, and even local district lines that the Citizens Commission isn't drawing, all of them have to provide roughly equal representation. And that's a mandate in the US Constitution. And so what does that mean? When we learn where the people are, we have to redraw district lines to ensure that each set of districts for each set of voters provides roughly equal representation. And so it is directly following this constitutional mandate that every 10 years, we conduct a national census. We've been doing it since 1790. It's one of the very first things the federal government is given to do in the brand new Constitution. Every 10 years, we conduct a federal census. And then immediately after, district lines are redrawn in order to ensure approximately equal representation across the board. We're coming up on the 2020 census. In 2021, as you know, the commission that you will help select has the responsibility to redraw lines based on our new knowledge of where the people are. Where the lines are drawn is the bulk of the redistricting task. And unsurprisingly, the bulk of my presentation today. The first mandate is a US constitutional mandate. I just mentioned it, for equal representation. And there are rules requiring equal representation in the federal Constitution. Those are refined a bit by the state constitution, and they're further refined by state statute. The federal Constitution sets out that there shall be a reasonably equal number of people in each district within a jurisdiction. So for your purposes, for the Citizens Redistricting Commission purposes, there have to be a reasonably equal number of people in each congressional district within California, in each state legislative district within California, and within the Board of Equalization districts in California. The mandate for congressional districts is driven by Article 1, Section 2 of the US Constitution that provides representation in the US House of Representatives. And the way that the courts have interpreted this mandate, including most recently in a Supreme Court case from 2012, coming out of West Virginia, but applying to the country as a whole, is that small differences in population from congressional district to congressional district are acceptable if they're there for a legitimate reason. The background for that case, West Virginia had drawn congressional districts that closely mirrored its county lines. And in doing so, had drawn districts that didn't have exactly the same population from district to district. And the Supreme Court said, that's okay if the difference in population is small. In West Virginia's case, there was a variation of about 0.79%, quite small. And that's probably the range that the Supreme Court will tolerate. We don't know exactly how much they will tolerate, but modest differences in the population from congressional district to congressional district are legally okay. The mandate for state districts has a different source and a bit more latitude. The mandate for equal population in state districts comes from the Equal Protection Clause of the 14th Amendment. And there, a series of cases, affirmed and confirmed with increasing frequency so that it seems quite settled at this point, says that distinctions in the population of each district from district to district are fine, are unremarkable if there's less than a 10% difference from largest to smallest for a legitimate reason. And the list of legitimate reasons are vast. Everything in the California Constitution, everything in California state law would count as legitimate reasons under Supreme Court precedent. There's been only one reason deemed illegitimate, and that is a population deviation put in place for partisan purposes. That's otherwise precluded under California's state constitution. We'll get there. So if the commission is doing what it shouldn't run into trouble as long as the deviation is less than 10% from largest to smallest for a legitimate reason. Even deviations over 10% are acceptable if the reason's good enough. And the Supreme Court has shown some latitude to exactly how much population disparity they will allow. But they've set 10% essentially as a safe harbor. Within 10%, we're not going to bother looking. Over 10%, we're going to pay closer attention to make sure that your reason was really good enough and required the deviations that we see. And those are the bounds for the federal constitution, that the federal constitution sets. How does this work in practice? It's relatively straightforward arithmetic. This is obviously a dummy example of a jurisdiction with 10 districts, a total population of 10,000 people. That means the average, often called the ideal population, and I'll get to this in a second. That doesn't mean what many people think it means. The average population, 1,000 people per district. 10,000 people in the jurisdiction as a whole. 10 districts, on average 1,000 per. And naturally, the districts will vary a bit in terms of their size because they're drawn for lots of reasons and not just to equalize population. I say, though this is, the average population is known as the ideal population, that's a technical term and not a normative baseline. It may in fact not be ideal, as we're used to using that word, to have each district be exactly 1,000 people. Seeking the precise average, seeking to make sure that each district is exactly equally populated, inevitably involves trade-offs. it inevitably will mean that it's more difficult to satisfy some of the other conditions that California law lays out for what it wants districts to achieve. And so that average is a mathematical figure, but not a goal, at least not strictly. How do these districts fare? If those are state legislative districts, are they constitutional? The way you'd figure that out, you'd see how much each deviates from the average. You can see there's one district that's considerably smaller than the norm, one district that's considerably bigger than the norm. Together, that's a total deviation of 11%. And that's going to be a district plan that's going to provoke constitutional scrutiny, where a court would look to that to say, you've surpassed the 10% safe harbor. I want to know why you had to make the districts this way and that there was a good reason for it. I want to emphasize, this is not unconstitutional. It just draws the scrutiny. It gets put under a magnifying glass by a court. Had that deviation been less than 10%, if there were 960 people in District 4 and 1,040 people in District 9, had the deviation been lesser, then it would not provoke constitutional scrutiny really at all. Less than 10%, safe harbor, we're not going to pay much closer attention. State law adds to this mandate and refines it a bit. You may have heard there is a controversy in some parts of the country about exactly what equal representation means and whether that's a reference to equalizing the number of people within each district or equalizing something else. Whatever the scope of that controversy in other parts of the country, California settles the matter and is absolutely clear in its state constitution that the thing to be equalized across districts is total population. The number of people within each district has to be roughly the same. The California state law says that congressional districts are to be as nearly equal as is practicable. As is practicable is a term of art. It means, in most contexts, get as close as you can without sacrificing too much of the other criteria you're asked to pay attention to. That's distinct from, or at least it's a different set of words from, as nearly equal as possible, which generally in the law is a tighter requirement. State districts have even more latitude. The California Constitution asks that the state districts be reasonably equal, and even makes an exception to that suggestion that the state districts be reasonably equal, allowing for greater deviations when required to comply with the Federal Voting Rights Act or when allowable by law. I don't believe that language has been interpreted by the courts, but I take that to mean that if other criteria in California's Constitution suggest greater deviation in population is necessary in order to achieve keeping a city whole or keeping a county whole, or complying with the Federal Voting Rights Act, or keeping a community intact, that there is explicit permission given in the California Constitution to allow districts to vary up to the federal constitutional threshold. That is, I take that articulation of the population mandate for state legislative districts to allow maximum deviation under the federal Constitution in order to comply with these other characteristics. Put differently, the California Constitution seems to say that districts should not be precisely equally populated, if that means sacrificing any of the other objectives contained in the Constitution. And candidly, though I am a big fan of the work of the 2010-2011 Citizens Redistricting Commission, and though I believe that all of the commissioners were not only exceedingly able, but had the interests of the state and their own exceedingly independent and nonpartisan mandate firmly in mind, they struggle here. A few other places that I'll mention as well. Recall that the California Constitution explicitly says that districts are to be reasonably equally populated, not precisely equally populated. And even that reasonable equality has an exception where it's allowable by law to be more disparate. The state law, that is, says that districts not only can be, but should be able to vary in population up to a federal constitutional threshold in order to achieve other goals. In 1973, the California Supreme Court set rules for itself under an older version of the California Constitution, different language than the language I've just been speaking to you about. And the California Supreme Court said that when it was drawing the lines, it should keep to within a 2% deviation in population. And whether because of that old and now outdated, because there's been specific new and different language since, whether because of that case or otherwise, the commission seemed to adopt a roving set of guidelines for how much population deviation they would permit. And I think very few of them comport with California law. First, the commission decided that it would seek to keep districts populated plus or minus 2%. Then it decided plus or minus 5%. That's up to the federal constitutional "we're going to look closely" threshold, with an explanation for any deviation over 2%. Then the commission sought to equalize as much as possible up to 5% total. Then 1% total. Then 2% total. And finally, with a little tag on to permit unequal population when required by the Voting Rights Act. That last decision is where the commission landed, and I'm not sure that it comports with the California Constitution. I read the California Constitution to not only permit more flexibility, but at least where additional flexibility would allow other goals to be met, to require more flexibility. The final districts were all within 2%. And I don't know if that reflects a choice by the commissioners to settle on a number, or whether that reflects examination of all of the other criteria, drawing the districts, and the districts happened to end up with 2%. We don't know. But the fact that the commission chose outwardly a series of thresholds that, in my view, did not reflect the California Constitution leaves me suspicious that its final lines might actually have deviated from what state law required. Why is this important? Why mention this at all? Because every redistricting decision has trade-offs. If you seek to maintain more population equality, you may limit the opportunity to provide equitable minority voting power. You may limit the opportunity to preserve the bounds of cities or counties or neighborhoods or communities of interest. You may limit the opportunity to draw districts that are compact. You may limit the opportunity to draw districts that are nested. I'll get into some of these other criteria. These are some of the other things the commission is asked to do. But every constraint in one place constrains other opportunities to fill the constitutional mandate. So what's the upshot of all this? Essentially, the law allows the commission to set a default threshold for population variation, something to aim for, but the standard need not be tiny. A modest amount of deviation is acceptable for Congress. A somewhat more expansive deviation is acceptable for state legislative districts. And particularly for state districts, the law requires the commission to depart from this default in order to achieve other objectives. It's okay to have something in mind to aim at, but if it helps you achieve other things, the commission is required to allow districts to vary in population in order to achieve those other objectives. There's one more aspect of equal representation that I want to draw to your attention, and then I'll stop for questions. And that is a mandate set in place by state statute. I've been talking about the federal constitution. I've been talking about the state constitution. There's one additional state statutory impulse. And it comes out of, or can best be explained by, an example from Lassen County, California. In Lassen County, the overall population of the county is 1% African American and 11% Latino or Hispanic. But there is a large prison complex in Lassen County, several actually, that overall represent 27% of the county's population. And the individuals incarcerated in those facilities are very different from, demographically, socioeconomically, and otherwise, the surrounding electorate, the surrounding population of Lassen County. Although the county itself as a whole outside of the prison is just 1% African American and 11% Latino, the prison population is 27% African American and 35% Latino. And often, the individuals who are incarcerated in Lassen County aren't from Lassen County. That's not where their last residence was before they were incarcerated there. That's not where their families or friends or relatives or jobs are, by and large. And it's not where they will leave. It's not where they will settle after they are released from prison. This can have a distorting impact on representation if the individuals who are incarcerated are counted for districting purposes where they're incarcerated rather than where they're from. And several states, including California, have sought to correct that skew. California state law, Election Code 21003, requires the Department of Corrections to make available statistics on the number of people incarcerated in each facility and their ethnicity, race and ethnicity, and where that information is held, their last known residences before they were incarcerated, the places from which they were pulled. And you'll hear from my colleague, Karen McDonald, how this translation is made. But the legislation requires the database supplied for redistricting purposes to contain information on not only the population in prison, but where they were last from, so that the Citizens Commission, if it chooses, can make an adjustment. And the legislature has requested, I would frame that as a rather strong request, the Citizens Commission, when it does the work of drawing district lines, to deem each person who is incarcerated as residing not where they are in prison, but instead at their last known place of residence. This sort of adjustment makes a lot of sense from a policy perspective, but I won't go into the policy reasons for it at the moment. What's important for these purposes is the California State Legislature has required that the information be made available and has exceedingly politely asked the Citizens Redistricting Commission to take that information into account, adjusting the population count delivered by the census to include individuals who are incarcerated at their last known place of residence. One of the things the commission will have to do is decide whether to grant this request. And it is framed as a request, but it's an extremely strong request with a lot of legislative oomph behind it. And then actually apply the translation. Again, Ms. McDonald, I think, will review actually how the data is prepared and how the data will be delivered, but use the data they're given in order to adjust the formal count that comes from the census in order to draw district lines. What does all this mean for the people you're going to be choosing? Well, first, your commissioners will need basic numeracy. Right? Enough familiarity with quantitative facts and figures to be able to at least review calculations of the population in each district and deviations from the average in order to assess whether they've met federal and state guidelines. Staff may be available to do those calculations, but the commissioners need to know what they're looking at if the staff make those assessments. They also need to understand the limits of data, what the data they are getting shows and what it does not show. And in particular, they need to know or be able to understand the data delivered to them that shows the residence, for example, of incarcerated individuals and how that's different from what the census may provide. And most important, perhaps, for these purposes, and you will hear me say this over and over and over and over and over today, the commissioners will need comfort with the notion that the quote-unquote cleanest answer isn't always the best answer, and in fact, may not be the legal answer or the lawful answer. It is tempting when told that there is an equal representation mandate to seek perfect population equality in each district. And if that means sacrificing other objectives, that is unlawful. It's a little bit like having a speed limit sign. A speed limit tells you how fast you are not permitted to go more than, except in certain circumstances. If you're an ambulance, you can probably go faster than 65 on the highway. If you're a police car, you can probably go faster than 65 on the highway. If you're a Formula One race car, you can certainly go 65. In fact, if you're only going 65, you're probably losing. Having a speed limit does not suggest that the right speed is 0. And in fact, traveling 0 on a highway, on a freeway, may well land you in quite a bit of trouble with the law. And so you need commissioners who can understand that there may be thresholds for presumptive or default maximums, but that does not mean the right answer is the minimum. There'll be a number of different circumstances today when what seems to be the obvious conclusion or the cleanest conclusion or the easiest conclusion isn't the right one and isn't the most lawful one. And that may well be the most important trait that you're looking for in prospective commissioners for the pool. In addition to that, it is nice for the commissioners to be able to understand different ways of presenting the data. This is a map of California as a result of the 2010 census. And it describes the percent change in population by county over the last decade. Green means very rapid change. Dark green means more rapid. Lighter green means less rapid. Purple means negative change. So growth in the green, decrease in population in the purple. What that means for redistricting purposes is you're likely to need more districts of smaller size down in Riverside. Population has been growing. That's going to mean more districts in order to accommodate an equal number of people or a reasonably equal number of people in each district. It's likely going to mean a little larger districts and perhaps fewer districts in the north, where population has been declining. These sorts of ways of analyzing the data may help commissioners know where to focus as they fulfill the equal representation mandate. These sorts of visualizations can help describe where some of the activity or increased activity of the commission will be. I don't think it's necessary for commissioners to be able to read and understand maps like this, but it is useful. It's a handy shortcut. Before I go on, this is a good time to find out, are there any questions on what I've just gone over? And I'm happy, I take questions from the audience at the panel's prep.
The census asks for population figures. The word population has been used throughout. Do you mean citizens or do you mean population?
So it's an excellent question. What the gentleman's referring to is what I mentioned as some of the controversy in other states. There is a question in parts of the country about whether population or citizens or something else is the appropriate measure. I have views on that elsewhere, but California law has resolved those views for me here. California law very clearly says population total, not citizens, not voting age citizens, not anything else, population total. And that's in the California Constitution itself. And so regardless of any dispute out there sort of in the larger political context or elsewhere in the country, population, California has answered your question definitively, total population. It's a good question. So the second large bucket of factors that the commissioners will have to account for concern race and ethnicity. I have given semester-long courses on the Voting Rights Act, and even those leave out a lot of information. So I will try and condense as much as I possibly can here. And I think I can describe the requirements of the federal constitution, of the state constitution, of the Voting Rights Act in 3 basic rules. Number 1, don't set out to hurt voters based on their race or ethnicity. That's a federal constitutional rule. That's also a state constitutional rule that is also embodied in the Federal Voting Rights Act. If the commission attempts to limit the voting power of voters based on their race or ethnicity, that's unlawful, flat out. What do I mean by that? If you imagine that that is, again, a very artificially drawn jurisdiction where the circles of color represent people of color, some in the past jurisdictions have set out to limit the electoral strength of a minority population by what's known as cracking. drawing the district lines so that they cut through a minority community, so that the minority community reliably loses elections in each district. When done intentionally, this would divide the minority voters up among the districts so that they would be likely to lose in each, and would clearly violate, again, when done intentionally, both the federal constitution and state law. Another means to limit minority power is called packing. That's the act of drawing the districts to contain as many minorities as possible in one district so as to leach strength from the surrounding areas. If cracking attempts to deprive minority populations of representation throughout, packing acknowledges some measure of minority representation, but seeks to limit that representation by combining as many people as possible into one district, over concentrating power in that one district and limiting power in the rest of the jurisdiction. Both of these are clearly unlawful if that's the intent of the body drawing the lines. It does not matter if the lines are pretty. Lines can be used to unlawfully crack or pack minority populations and dilute their power, even if they appear regular, even if they appear even, even if they appear uniform. And it does not matter if racial dilution is the ultimate motive or just a means to an end. It may be in some jurisdictions, those drawing the lines have intentionally sought to limit minority voting power in order to achieve partisan ends, in order to achieve personal ends. The ultimate motive doesn't matter. What matters is, were minority communities targeted for a deprivation of their voting power? If so, clearly unlawful. The Ninth Circuit, the Court of Appeals that sits over California, among others, made this point really clearly when asking whether you can have this sort of discrimination, even if there's another ultimate motive in mind, in a case coming out of Los Angeles in 1990. The judges gave the following example. Imagine they say that you're a homeowner and you live in an area with a homeowners association or another residential community, and you harbor no particular ill will toward racial minorities, but the rest of the neighborhood comes to you and says, please don't rent to those people. Property values will go down. And as a result, even though you may harbor absolutely no ill will toward minorities, you decide not to rent to, quote unquote, those people in order to keep property values up. Have you intentionally discriminated against racial or ethnic minorities? Of course you have. Obviously you have. The ultimate motive doesn't matter. This isn't about hate in one's heart, although that certainly can be an issue. The point is that intentionally treating minorities worse because they are minorities is unlawful, and that is as true in redistricting as anywhere else. So rule one, it's a fairly straightforward rule. Don't set out to hurt a community of voters because of their race or ethnicity, period. Rule two is a little more complicated. Comply with the Voting Rights Act. The Federal Voting Rights Act is a nuanced statute that says, essentially, under certain conditions, jurisdictions may have the federal responsibility to design districts so that they provide equitable electoral opportunity based on race or language minority status. What does that mean? Again, I can try to oversimplify. The Voting Rights Act asks a series of questions in order to determine whether a jurisdiction has a responsibility, and if so, how to fulfill that responsibility. This presentation has changed since 10 years ago. There used to be more to the Voting Rights Act that California had to worry about. At the moment, there's a dormant portion of the Voting Rights Act, so this reflects current law. There are always proposals on the horizon to amend or restore the Voting Rights Act. So this, like any laws the Commission will have to apply, may change at any moment. But for the moment, the primary piece of the Voting Rights Act that applies in California and that will apply to the Redistricting Commission, the folks that you're screening into the pool, is Section 2 of the Voting Rights Act. And it asks first, are there sizable, relatively concentrated minority populations? I'll get into what each of these mean in more detail. Do those minority communities, if they exist, have distinct electoral preferences? Do those minorities, or did those minorities, face discrimination? And if so, if the answer to all of those questions is yes, can we design districts to give minorities a fair shot, an equitable opportunity to elect the candidates of their choice? That first question, are there sizable, relatively concentrated minority communities? The courts, the Supreme Court, has interpreted to ask, are there minority communities that constitute more than half of the electorate in a district-sized population? By electorate, here to the gentleman's question before, the courts generally mean citizen voting age population. The Voting Rights Act is responsive to electoral power. The equal representation mandate is responsive to representation and presence. So the equal representation mandate counts total population, period, but the Voting Rights Act is concentrated on electoral power and has a different basis for how it works. Are there sizable, relatively concentrated minority communities in a district-sized population? And we talked earlier about what a district-sized population is in California. Are half of the electorate, half of the citizens of voting age, minorities? How do we know this? The easiest way is to look at a map, or to have someone else look at a map and assess their evaluation. This happens to be a map of population by race and ethnicity in Los Angeles from 2016. And looking at that map, someone who is trained in reading this sort of display can see pockets that are relatively concentrated. This is not a broad area of the state, right? There are lots of people, but it's in a relatively confined geography. Pockets of population who are non-Hispanic white, purple dots. Pockets of population who are African American, blue dots. Pockets of population who are Latino or Hispanic, orange dots. Pockets of population who are Asian American. These come from self-identification on the census. The particular graphic is put together by a demographer. And someone trained in reading a graph like this can see, I suspect that there are sizable numbers of minorities that are relatively concentrated that I can see here in that region. I can see pockets of Hispanic or Latino population. I can see pockets of African American population. I can see pockets of Asian American population. I would next have to drill down and say, okay, let me find district-sized versions of that. And let me slice that into district-sized buckets. And then I would have to overlay citizen voting age population data to figure out if those minority populations constituted more than half of the electorate. So some geospatial information, some census information, and some relatively basic math. If there are sizable, relatively concentrated minority communities, if there are minority communities that constitute more than half of the electorate in a district-sized population, the next question is whether those minority communities have distinct electoral preferences. Do African American citizens vote differently from others? And the way the Voting Rights Act has been interpreted, it asks both whether persons of color generally vote differently from the Anglo population, but also whether individual minority groups have distinct preferences from other individual minority groups. If it turns out that African Americans prefer the same types of candidates as Latino voters, but different types of candidates than Anglo voters, in a particular region, this is very localized, the law says that voting is polarized between Anglo voters on the one hand and African American and Latino voters on another. If the data show that African Americans have distinct preferences from Latino voters, who themselves have distinct preferences from Anglo voters, then voting is polarized along two different dimensions. Right? Each group has a polarized voting pattern distinct from the others. This is not a question for assumptions. The court has been very clear. And this is not a question where assumptions necessarily translate from one part of the country to another or one part of the state to another. This is based on data and local elections to determine whether preferences are distinct. In some parts of the country, they are extremely distinct. In some parts of the country, for at least some minorities, not so much. And so this is an empirical question. How do we determine? I'm not going to go into all of the basis for determination today. This is a very rough regression that's meant to show part of how these calculations are made. Essentially, each circle represents a precinct. And you can plot the demographics of the precinct and the voting results of the precinct to see if they show a pattern. Over elections and over time, this is almost never done with just one election, or at least the results never rely on just one election. A pattern may emerge where consistently the candidates who do best in precincts with the highest percentage of minorities may be distinct from the candidates who do best in precincts with the lower percentage of minorities. And there are various quite sophisticated statistical techniques to determine whether these preferences diverge based on assumptions about called an ecological inference, based on assumptions about the voting patterns of the individuals within the precinct. The more data points you have, the more reliable the estimate. The fewer data points, the less reliable. Some elections are more meaningful than others in this respect. It may be, and the Federal Voting Rights Act reflects this, that elections involving at least one candidate of color will show you a distinction in the preferences of the electorate, where elections among Anglo candidates may not. That is, it may be that elections purely among Anglo candidates, communities of color may say, whereas they may have very distinct preferences when the elections actually involve a candidate of color. It's not going to be true in every case. It's an empirical question. Primaries may be more meaningful in sussing this out than general elections, where the voters don't necessarily have party to guide them as a cue in distinguishing, but may in fact have individual within party preferences. And as you all know, statewide elections may have different results than local elections. California has a statewide system that now has a jungle, what's called a jungle primary. Lots of candidates of lots of parties, and the top two proceed to the next election. More local elections may not feature that aspect. People may actually have fewer partisan cues, and so may choose candidates, not based on the candidate's race, but based on distinct preferences of the race or ethnicity of the voters. It would be unlikely that you would be choosing commissioners to do this analysis themselves. There are comparatively few national experts in this zone, say dozens rather than hundreds. They are unsurprisingly in high demand at the start of every redistricting season. And most redistricting bodies, legislatures and others, employ these experts to do what's known as racial polarization analysis, to test the empirics locally on whether it can be shown from the data that minority communities have distinct electoral preferences. But the commissioners may well have to understand the reports that those experts generate. If there are sizable pockets of minorities, and if those minority communities have distinct electoral preferences, the next question the Voting Rights Act asks is whether those minorities are underrepresented and whether they face discrimination. Actually, I should clarify before going on to this. Just one note. For those who are quite sophisticated at the statistics, this is a way of explaining the techniques of ecological inference that are, I would say, of modest sophistication, but hopefully make the overall approach clear. There are far more sophisticated tools that employ bounds, that employ techniques of Bayesian inference, that employ different statistical techniques to make sure that the calculation is more accurate, that the experts actually deploy in most circumstances. So I'm not presenting you visually the state of the art, but this may be a way to explain what the analysis in total is getting at. There are far more sophisticated means of doing the statistical analysis that the actual experts are well versed in and can deploy on a regular basis. And these sorts of techniques are used not only in conducting redistricting around the country, but in litigation over redistricting around the country. The techniques have been validated by courts over time. So, if there are sizable pockets of concentrated minorities, if those minority communities have distinct electoral preferences, the next question is whether those underrepresented minorities, whether those minorities are underrepresented and whether they did or do face discrimination. The Voting Rights Act has a number of factors in what it calls the totality of the circumstances in determining whether there is a responsibility under federal law to draw districts tailored to minority electoral opportunity. Here too, the normal course is to engage an expert in Voting Rights Act analysis who will assess the degree of local discrimination, who will assess the degree to which a minority population may already have reached proportional electoral opportunity. I don't mean to suggest that the commissioners need to walk through each of these factors. There are many. Only that they will likely need to assess the work product of experts they may engage. Overall, you can see that this entire process is very data-driven and very localized. The Voting Rights Act is resistant to assumptions. It demands instead real information about minority communities and their electoral preferences and the conditions they have faced. And then at that point, there may be a special responsibility. If the threshold conditions for that responsibility are met, then the question is, can we design districts to give minorities a fair shot, an equitable opportunity to elect the candidates of their choice? This is an iterative process, inevitably. To functionally do this work, and I know that Ms. McDonald will also talk about the mechanical practice of it in her presentation later, both of collecting the data and applying the data to actually draw districts. Commissioners will have to determine the approximate localized threshold for electoral effectiveness. What do I mean by that? About what concentration of minorities in a particular district leads to a reliably equitable opportunity to elect candidates of choice. The Supreme Court has been abundantly clear, and jurisdictions keep getting this wrong, and the Supreme Court continues to remind them that they're getting this wrong, that this is not a demographic determination. It is not permissible to assume that if there is a responsibility under the Voting Rights Act, that if you just draw a district at 50% minority electorate, that the job is over. It is based entirely on actual electoral effectiveness. Sometimes the concentration of minority citizen voting age population will have to be higher than 50% due to historical lapses in socioeconomic status, or due to historical discrimination. Sometimes those percentages will be lower than 50%. What's abundantly clear is that you can't just wave a thumb in the air and land on a demographic level of electoral effectiveness across the state. Once you figure out in the area, in the Sacramento area, or Bay Area, or Southern California, or maybe the distinction is different in Orange County or in Los Angeles County. Once it's known what the approximate electoral threshold may be in that area, again, that's a that's driven from past elections. You seek pockets of population containing communities with that effective electoral strength. Not too much more, not too much less. You consider other criteria at the same time. I'll get into that in a second. You build a district that looks, considering all of the other criteria that you're evaluating, like it will provide reasonable electoral effectiveness. And you repeat, you go back and you check. Did I in fact get this right? Do I need to adjust?
I think we haven't stopped for questions for a bit. So I'm going to see if any of my panel members have any questions, and then
Please.
also the audience. So any questions? Audience members, any questions? And if you do have a question, come to the microphone, but you do need to state your name for the record. I forgot to have the gentleman do that. Any questions? Proceed to the microphone and please state your name for the record.
I'm Daniel Quincy. So just to follow up, so the size of districts is population based,
Correct.
but the adjustments that you're going to make drawing the lines is citizen voting based.
Some of them will be. Yes, it's an excellent
Where
question.
necessary. Where necessary.
Yes, so adjustments based on the Voting Rights Act in particular will be based on citizen voting age population. That's right. Ms. McDonald, I know we'll talk about some of the sources for that information. We've had sources for that information from a long time, not from the decennial census, but from surveys that have accompanied the decennial census, and then more recently surveys that are rotating over a 5-year span. But yes, for purposes of complying with the Voting Rights Act, citizen voting age population is important. Total population is also important, right? You have to know that the minority community is half of the electorate in a district-sized population. So the commissioners will need to be able to consider both. They'll need to have sort of two running tallies, not just in their heads, usually on a screen, but they'll need to be able to account for both. That's right. There are other criteria that I haven't gotten to yet, we'll get to in a little bit, that also reflect different population figures or different population estimates. But you're right.
You have a second question? We have 2 minutes.
Certain ethnicities have a historical record of very low citizen voter participation.
Correct.
What do you do?
So that is precisely where, it's another good question. That is precisely where the commissioners will be asked to determine the localized threshold for electoral effectiveness. There may be some communities or some ethnicities in some communities, right? This is not overall national stereotype. It's very locally based, that may have particularly low records of turnout, in part based on historical discrimination or otherwise. And the assessment of what level of that minority community may be necessary to establish effectiveness, effective opportunity to elect the candidate of choice, is going to vary based on the group, based on the location, based on historical records, right? It is usually the case that districts that are designed for effective minority opportunity see a modest increase in turnout, the same way that I might be inclined to try a little harder in a track race if I'm racing my spouse or parents than if I'm racing Usain Bolt. The opportunity to win will in fact inspire more participation than the clear failure or lack of an opportunity to win. But all of those calculations are based on historical data, actual election data. All of them are rigorously quantitatively based, and there's no thumb in the air answer for about how many people do you need in any one region that's independent of the local context.
Excellent, thank you. So it's now time for a break. It's 10:30. We'll reconvene at 10:45.
to assess qualitative and historical context. All of these things are things that experts can and should assist them with, but they'll need to review those expert reports and determinations. Beyond that, beyond the ability to hire appropriate experts and ability to assess expert determinations, they'll need to be able to assess mapped indications of where minority populations are. Right? They'll have to figure out where they may have particular responsibilities throughout the state and where they may not have those responsibilities throughout the state. Not all parts of California will be equally subject to the mandate to build districts where minorities have electoral opportunity. They'll need to understand the limits of the data they receive, what's there and what's not. And I'll say again, they'll need comfort with the notion that what may seem like the cleanest answer, often in popular construct, the building of a majority-minority district at over 50% minority population, not only may not be best, but may not be legal. The actual law requires more granular detail. And so what may seem like back of the envelope surface level, quote unquote, obvious, may actually be unlawful. Again, you'll see that a lot. Commissioners will also be able to need to creatively reconcile rights of minority multiple communities where minorities live side by side, as they do throughout so much of California. And they may well, in that process, need comfort drawing districts with shapes that seem strange. I put strange in heavy quotes. I'll get back to that a lot. The cleanest example I can give you of this is from Chicago. Chicago, and particularly the west side of downtown in Chicago, is a place where multiple minority communities live side by side. And some decades ago, redistrictors set out to draw districts representing the multiple minorities of Chicago's west side because they determined that through all the things that I mentioned before, there were sizable pockets, they had distinct electoral preferences, and there was, in fact, a responsibility under the Federal Voting Rights Act to draw districts that provided equal electoral opportunity. That's a map. I've sort of grayed out the underlying map so it may be harder to read, but it just puts it in a little bit of context. That's a map of the Latino and Hispanic population by census block in the west side of Chicago, and the African American population by census block in the west side of Chicago. Latino Hispanic population in orange, African American population in purple. And you can see this is a relatively small area of the state. If you're talking about congressional districts, and we are in this context, it's a relatively small area of Chicago with two minority communities living side by side. That's where we're talking about. That's to scale where we're talking about Illinois. So these are not minority communities that are spread throughout the state in really small tendrils, concentrated in a small area of the west side of Chicago. It would have been possible to draw a district that looked relatively clean to encompass the Latino Hispanic community, to build a district around a large concentrated Hispanic community that cut right through the heart of the African American community in the middle. Hispanic community lived on the north side and on the south side of an African American community, essentially paralleling some of the lines of the streets leading into downtown Chicago. Lots of reasons for why historically the population developed and grew in this way. But population just to the north, population just to the south, similar electoral preferences. Would have been possible to draw a district cutting right through the African American district in between and depriving that African American community of their opportunity to elect candidates of their choice. It would have been possible to draw a relatively clean looking district serving the African American community. And in so doing, cutting through the Latino community to deprive them of the equitable opportunity to elect the candidate of their choice. And I should mention that in Chicago, as elsewhere, African Americans and Latinos did not have similar electoral preferences distinct from the Anglo population. They had, unsurprisingly, very different electoral preferences from each other. The candidates preferred by the Latino community were not the same as the candidates preferred by the African American community. So drawing a relatively clean district for Latinos would have deprived African Americans of their distinct choice when there was a responsibility instead to grant that opportunity. And drawing a relatively clean district for African Americans would have done the same for the Latino population. So the redistrictors drew that. And if I take out the population, you can see a district combining the communities of North and South in orange, designed to effectuate Latino opportunities to elect candidates of choice, and a district through the center of the same area designed to elect candidates responding to the African American community there. The populations are all in the same area, but the districtors got creative about how to represent those very distinct preferences in the same place, based on a mandate to do so from the Voting Rights Act. This district has been called the earmuff district, and for people who do not understand the law and who don't place a great weight on representation, this district has been much mocked. But among those in the redistricting community who understand why this was drawn as it was, it's actually a district appreciated with some reverence. So much so that, and I swear this is a real photo, two of my colleagues who do redistricting work actually had it printed on their wedding cake. They live in Illinois, they live in Chicago, and they understand what this district was drawn to do. This is a not only legally compliant district, but one that satisfies several criteria that the drawers were asked to pay attention to. And I mention it, I emphasize it, because comfort drawing these districts and being mentally flexible, rather than defaulting to a default about what districts should look like that's not grounded in the law, can be hard, and is something that I think you can and absolutely should screen for to the extent that you're able. Right? That's not something everybody is comfortable doing, but it is assuredly something that 14 of the individuals or 60 of the individuals or 120 of the individuals in your pool will be comfortable doing. And that's something I encourage you to strive to find. We pause there for a real quick check for questions about the Voting Rights Act in particular. I'll come back to this concept of shape in a second, but getting into other rules in state law now before I go on, I'd love to see if there are questions.
Seeing none?
That's the Voting Rights Act in a nutshell. That's rules about race and ethnicity in a nutshell. Congratulations on reaching the end of the semester. There are an additional set of rules in state law. You see, we've talked about equal population that has both a federal and a state mandate. We've talked about race and ethnicity, largely comes from federal Constitution and the Voting Rights Act. There are a few other criteria that state law asks the members of the Citizens Redistricting Commission to apply, each with their own traits that are suggested out of that. We'll take them in order. Contiguity, and these get simpler, by the way, lest you be concerned that we're, an hour and a half into the presentation, we still have a bunch to go. These are much simpler. Contiguity. The easiest way to discuss continuity is to talk about the state of Nevada, which is the only state in the union that I'm aware of where it is entirely lawful to draw a state legislative district that looks like that. Nevada has no rules that its district have to be contiguous, that parts of the district touch each other. So you could, if you wish, draw a district that was entirely disjointed in Nevada and still be compliant with Nevada state law. That is not the case in California. California has a rule that requires contiguity. All that means is that all parts of the district are connected to each other. And I know Ms. McDonald will talk about some of the various ways to satisfy that criterion that you see in actual redistricting practice. One that I'll highlight is that islands, unsurprisingly, create special conditions. Knowing that all parts of a district have to be connected to each other leave you several choices about where to connect islands. And California has a few. I choose the Channel Islands, the Northern Channel Islands, just because it's not immediately obvious whether they should be connected to Santa Barbara or to Ventura or to other parts of the coast entirely. The commissioners will have to make those choices about what it means for the Channel Islands to be contiguous with other parts of the district map that meet the coast. It is unlikely that connecting the Channel Islands to the Bay Area with nothing in between would satisfy contiguity. But in the general region of Southern California, there are multiple choices for where the Channel Islands could be plausibly attached and still be considered touching each other. One common approach is to follow ferry lines or lines of transportation. But that's not the only common approach. That's not the only plausible approach to decide where islands are connected to other parts of the mainland. What does this mean for your commissioners? This one's pretty easy. Most redistricting software tests for contiguity. That's a good thing. Essentially, it just means they'll need to be careful that all parts of the state are accounted for. They haven't left anything out. Hopefully, there will be lots of opportunities to point out in the process if they happen to have left some part behind. California Constitution also asks for attention to municipal geography. And here, the Constitution has a very distinct definition of what that entails. The law requires that the commission attempt, where possible, to keep intact cities, counties, neighborhoods, and something called communities of interest. Now, I want to say right off the board, the equal population mandates and the Voting Rights Act mandates may make this not possible in certain circumstances. And the law is set up explicitly to acknowledge that it may be necessary to divide a county or a city or a neighborhood or a community to satisfy equal population mandates and Voting Rights Act mandates. Los Angeles will have to be, both city and county will have to be divided into multiple districts in order to satisfy equal population mandates and in order to satisfy the Voting Rights Act. That's a fact. And that's not a problem under the law. But where it is possible without otherwise doing damage to the criteria the commission is supposed to accomplish, is supposed to effectuate, the commissioners will need to account for keeping cities and counties and neighborhoods and communities of interest together where possible. Cities are defined. Counties are defined. Neighborhoods may or may not be defined. Some localities, including, for example, Los Angeles, where I live, have defined neighborhood representatives from neighborhoods that the city has designated. The commission can use those definitions, but needn't. There's no mandate that they adopt inherently this definition of a neighborhood that a local municipality has come up with. Communities of interest are actually defined in the law. I'm not going to sit here and read this to you. But that definition allows a lot of flexibility. And I know that you're going to hear Ms. McDonald talk later about all of the ways in which you draw data to determine what communities of interest are. The last commission in particular put a priority on hearings and testimony in order to hear from the public what they considered to be their communities of interest. And that itself led to a fair number of challenges in simply amassing and processing that data, much less to giving it life. A community of interest is a population connected to each other that shares common social and economic interests that should be included within a single district for effective and fair representation. That's a lot of normative flexibility in that definition given to the commission. And what's important here is that there is no priority ranking in state law preferring cities to counties to neighborhoods to communities of interest. They're all given equal importance. And that means the commission will have to take them equally seriously. These lines may be irregular, and commissioners will have to be comfortable with that. That's the city boundary for the city of Los Angeles. And that may seem odd or unusual or perhaps unappealing. I happen to think it's quite pretty. But whatever it seems abstractly plotted on a blank slate of screen or paper doesn't restrict the fact that where possible, the commission has a mandate to try and keep it together in one place, in one district. Not possible for the city of Los Angeles, way too many people. But smaller cities are equally, they look similar because of annexation battles, they look similar because of local urban planning, they look similar because of local terrain, and may well have irregular lines. Within the city of Los Angeles, there are neighborhoods defined by the city that are themselves irregular. That's the neighborhood boundary for a neighborhood that the city calls the Harbor Gateway North. That's the neighborhood boundary for a neighborhood the city calls Bel Air and Beverly Crest. I'm told it looks like a hippo on the march. Those need not be the neighborhoods that the commission themselves adopt, but they are defined at least locally. And so there are at least neighborhoods that the commission may want to consider. And I just want to point out the lines may be irregular, and that is not something that should cause resistance among the commissioners when they're seeking to keep districts together. This isn't unusual. That's the city boundary for San Jose. On the right hand, the city boundary for San Diego. And you'll notice in particular in these boundaries, there are pockets that are cut off from other parts of the city or only narrowly attached to other parts of the city that in the abstract may seem like they should belong to another district. And the California Constitution says, where possible, we're not doing damage to these other interests, try and keep them together. You'll notice that San Jose even has a small piece that is not itself contiguous. It's not connected to the rest of San Jose. Small little annexation battle. Where possible, that little sliver in the northeast is to be kept with the rest of the city according to state law. Not only may the lines not be irregular, but as I've mentioned, they may not be precisely defined. Communities of interest, notoriously so. Commissioners may choose to further refine what communities of interest consist of through various data sources. It is possible, not required, but possible, to use census data on things like employment categories or household ownership or rental, or number of vehicles in a household, or socioeconomic status. Those may indicate communities of common interest, where a group of people has similar socioeconomic or demographic traits that may suggest common representation. The commission last cycle, I believe, didn't use much of that census data. I don't know how much of that choice was deliberate or not. Instead, they turned primarily toward hearing testimony and submissions at public hearings. And this produced quite a few public submissions, 2,700 speakers, 22,000 individual submissions. And I know you're going to hear much more from Ms. McDonald about how the commission grappled with processing this testimony last time and how a new commission might choose to do so in the future. Not only may the lines not be precisely defined, but they may conflict. This is a picture of the city of Columbus, Ohio, and the county boundary for Franklin County, Ohio. The county boundary is in black. The city boundary is in red. You see annexation irregularities are not unique to California. And if you look carefully, you see that parts of the city spill over the county. I don't believe there are places in California, although Ms. McDonald may correct me, where cities overlap county boundaries in California. This is quite common in other states. I don't believe that it happens in California. If it does, it doesn't happen often. But neighborhoods may well span city boundaries. Communities of interest may certainly span city boundaries and county boundaries. And so the commission may be called on to draw districts that have to resolve which boundary in a particular area is more important or less important. And again, that's not a decision that's set by the law. That's something the commission will have to deliberate on. Where a district could either keep a city intact or keep a community intact, the commission's going to have to decide which it prefers. What does that mean for your traits of your commissioners? Commissioners will need to distill and assess testimony, including quite prominent controversy last time, whether the testimony was sincere or not. One of the limits on considering a community of interest is that the community cannot be built around a political candidate. That is, it is not considered a community of interest for a bunch of people to say, I like Representative so-and-so, and that's our common community. There was a question the last time about whether certain candidates put up front groups to testify about their community of interest that so happened to overlap with the particular candidate's interests. Commissioners will be able to need to critically assess the testimony they hear. I'm skeptical that many of those efforts actually paid off. That is, I'm skeptical that the commission bought what it was people were trying to sell without recognizing the sales technique. But it would behoove you to choose commissioners who have the ability to discern or ask questions about the basis for the asserted community of interest. They'll need to reconcile potential conflicts in that testimony, even when there's no right or wrong. One person may say, our community is the following, and their neighbor living right next door may say, that's not our community at all. Our community is the following in a different place. It may be that neither is correct. The commission will have to decide how it chooses to process that conflict. The commission is going to need to be comfortable determining borders that aren't predefined. Cities and counties exist for them, but the other neighborhoods and communities of interest don't. And so they're going to have to be comfortable figuring out what they are willing to recognize as an appropriate municipal bound to keep in one district. They will, as you've seen, need to be comfortable with strange shapes or shapes that may seem strange. I put that again in heavy quotes. There's only something strange about the boundary of the city of Los Angeles if you expect it to look like something different. And they'll need to be able to reconcile potential conflicts, as I've mentioned, places where a community spills over a neighborhood boundary or the like, or vice versa. Let me stop there for just a second and see if there are other questions on this. Rolling onward. The next criterion that commissioners are asked to account for, and these now proceed in rough priority order, so that the commission is asked where it doesn't otherwise do damage to the other criteria. Consider compactness. Many think of compactness in terms of abstract shapes on a white screen or a white piece of paper. That is, in most people's understanding, the district on the left is not compact, the district on the right is compact. That's not what California law says. Under California law, I can't tell you which of those districts is compact or not. But the instinct is super strong to consider regularly shaped districts compact, regularly platonic geometry compact, and irregular geometry non-compact. And so you'll have to watch for the tendency to refuse to learn what California law actually requires. I'm going to get to that in a second. This is not California law. Some people, particularly I have found those gifted in the quantitative arts, think of compactness in terms of formulas. There are many different ways to measure the compactness of a district that have been discussed in academic papers, that have been applied in real science, that are sometimes used in other jurisdictions. Things like a comparison between the area of the district and an area of a circle that you create using the perimeter. Imagine a rubber band. Rubber band's the district. What's the area of that district? Now stretch out the rubber band to a circle. What's the area contained in there? Compare the ratios. That's a measure of compactness. It's particularly common in some redistricting software. For example, it's one of the ones that's always included as a feature of redistricting software to gauge compactness. There are lots of other measures out there proposed in the world, some more sophisticated, some less. There have been over 100 different proposals that I've chronicled, that I've logged, and the vast majority of them don't fit California law. So here too, watch out for preconceptions about what the law actually requires. California standard is very specific. It says, don't bypass nearby population for population that's farther away. Try and illustrate that. This is a map of California and its counties, and I'm going to focus on the Central Valley, right? The counties comprising the Central Valley. And you can see that very nicely and neatly, if you were only concerned with abstract geometry, and you were told to draw 2 districts in the Central Valley, there's a nice, neat set of county lines that suggest what you may think of as a compact boundary for those 2 districts, right? A west spine and an east spine. You draw right down the spine of the Central Valley. You get a district on the west and a district to the east. And in most conceptions of what compactness means, those 2 districts would be relatively compact. And you don't know anything about whether that fits California law at all until you know where the population lives. Because California says, don't bypass nearby population for farther population. And there's no information here at all about where the population is. So if I'm asked to say whether those districts are under California law compact, the right answer is I have no idea. If you lay the population down, and these are stats from 2000, you see that the population actually travels a bit along the spine. And in particular, if you drew the district that mostly followed county lines and seems kind of regular, right there, and what I believe is, that's not Bakersfield, it's going to be probably Fresno. Right in Fresno, you would cut Fresno in half. You would, in fact, if you draw the purple district, be bypassing the part of Fresno that's quite close for the population way up north that is quite a bit farther away. Let me say that again. If you drew the purple district, you would be bypassing the population that is right in Fresno, on the west side of Fresno, for the population farther north, and that would be unlawful. California's requirements, the state requirements, say that you may not draw districts with a focus on abstract shape at the expense of where the population actually lives. Pick people who are closer to each other, and that's how you know whether your district is compact or not. What does this mean? It means that commissioners will have to be able to identify population clusters. It means that, again, commissioners may need to be comfortable with quote unquote stranger shapes, shapes that appear strange. That's always going to be in quotes because it assumes a default. And they need to be comfortable with the notion that the cleanest answer, what seems like the cleanest answer, the most geometrically appealing answer, is not always best, and in fact, may not always be legal. The commissioners last time struggled with this too. And most commissioners will struggle with this. Because the instinct to choose districts that look pleasing to the eye in the abstract without population is incredibly strong and unlawful. Questions about this before I go on?
Is it desirable? Would one want to? And would there be time to poll a neighborhood and find where they want to go?
So it's another excellent question. I can't tell you whether it would be desirable, in part because I'm talking to what the law requires of the commission. I can tell you that the public hearings that the commission is required to conduct, in fact, accomplished that objective, that the commission asked for testimony from the citizens, from people in the area, not just the citizens, actually, from anybody who was going to be represented, and heard lots of preferences about where individuals, what groups individuals would want to be kept together with or separated from, and what common interests they might have. And so I can tell you that the last cycle, the way that the commission gave life to the requirement to provide communities of interest or neighborhoods is actually to ask the public. They did so in dozens of hearings, over 2,700 speakers, over 22,000 responses. And so it wasn't a scientific survey, but it was a form of getting response from the community that chose to participate. Let me move on to the next few criteria, and you can see we're getting to the end. This is a good thing. The nesting, all this means is that districts for varying offices are included within each other. That several assembly districts may be included within a Senate district, or that several Senate districts may be included within a congressional district or Board of Equalization district. Imagine that that's your Senate line, and that those are your two assembly lines. Those districts are not nested, right? The assembly lines are not nested within the Senate district. Contrast, if that's your Senate line, and those are your assembly lines, those assembly lines are nested within the Senate district. Again, California law is really clear. This is to be done only when it does not act to the detriment of the other more important priority criteria listed. And it is really important to know that a map that is valid at one level of representation may not be valid at another. Just as an example, if that is a valid map for the state assembly, it may not be possible, it may not be lawful to choose combinations of those districts to create a valid map for the state Senate if the state Senate district has to look like that for other reasons. That is to say, it is not always going to be possible to just add two assembly districts to each other to come up with a Senate district. There may be separate constraints and separate requirements at each level of geography. What does this mean? It means that commissioners will have to be comfortable reevaluating one map that they've drawn that's valid, potentially, if that map inevitably produces an invalid map for a different chamber when things are nested. They may have to go back and revisit some assumptions. It also means that they need to be comfortable not nesting districts when nesting would actually create compliance problems. And again, I keep saying it over and over and over and over because it may be the most important trait that you screen for. They need to be most comfortable with the notion that the cleanest action, always including two assembly districts in a Senate district or several Senate districts in a congressional district, isn't always the best answer and may not always be legal. The California Constitution also has requirements for dealing with concerning candidates and parties. And these are mostly prohibitions. The commission may not consider the residence of a candidate. And I'll give you a very quick story of any candidate, an incumbent or someone running for office. I'll give you a very quick story about why. This is a district in the south side of Chicago in the year 2000. In 2001, that district was redrawn to stretch across a different expanse of the south side of Chicago. Nothing particularly unusual about either the first district or the second district or the fact that they were redrawn. But if you look closer at the northeast part of the district, that's the 2000 border. That's where Barack Obama lived, who ran for office against then incumbent Congressman Bobby Rush in 2000. Bobby Rush was involved in the 2001 redistricting. That's the district boundary afterward. 1 block to the north, 1 block to the west, 2 blocks to the south of Barack Obama's house. That's part of the reason why California prohibits the commissioners from considering at all candidates' residence. You don't want districts that are custom tailored for incumbents under California law, and you don't want districts that are custom tailored against incumbents or candidates under California law. Here, the commission actually did pretty well. It did not, in fact, consider candidate residences. One of the reasons, one of the easiest ways to see that is what was known in 2012 as the Ehrman seat. It was a race between Howard Berman and Brad Sherman, 2 very prominent candidates, 2 very prominent incumbents in Congress, 2 very prominent fundraisers, both Democrats, who had for years been put in separate districts because they had access to the legislative redistricting process. And in 2011, the commission, which did not consider candidate residences, didn't consider the residences of those 2 gentlemen. They were drawn into the same district, and in one of the most expensive races of 2012 ran against each other because they were drawn into the same district. Nobody in advance knew who would win. They just knew it would be somebody whose name ended with Ehrman. California law also says the district shall not be drawn for the purpose of favoring or discriminating against a candidate or party. It's important to be really clear about this. That is not a mandate to intentionally draw districts to be competitive. The way that California nudges districts toward more competition is to prohibit districts from being drawn that are intentionally anti-competitive. Districts that intentionally privilege one party or another. California does not state that districts should be drawn to be affirmatively more competitive. California does not state affirmatively that districts should be drawn so that they're symmetric by party. So that if one party has, for example, 52% of the votes, it wins 54% of the seats. And another party, if it has 52% of the votes, wins 54% of the seats. That's a common metric in political science to assess the fairness of a map, and it is not one that California law specifies. California law does not have a mandate for districts to intentionally be drawn to achieve a particular score or to avoid a particular score on any of several quantitative measures of partisanship. I mention all of these 3 things because similarly with the population-based redistricting, there is a lot of attention out there in the world on ways to reduce partisanship or combat partisanship in the districting process. And obviously, California's Independent Citizens Commission, part of the motivation was to stop insiders from drawing districts that were favorable to themselves and that would produce districts that are lopsided in terms of partisanship. But California has chosen a particular way to go about this. it has chosen to prohibit the intentional drawing of districts to favor or disfavor candidates of the same party, of either a candidate or a party, pardon me. And to the extent the commissioners arrive with their own sense of what is fair on a partisan measure, or their own preferred measure of partisanship, if they deploy that measure to the detriment of other criteria that I've mentioned, they're violating the law. So here too, it is important that the commissioners be able to follow what the law tells them they are to do or not do, rather than bringing their own assumptions to what they might consider most fair, if those assumptions lead to violating the actual commands that they're given by the state law. And that can be hard. What does this mean for commissioners and their traits? They need to know that there's information they're not permitted to utilize, and they need to refrain from actually utilizing that information. They need to know that having a personal partisan affiliation is just fine, in fact, required. Right? You're sorting people into pools based on their personal partisanship, but they need to be able to set that aside when drawing districts, because they're not permitted to draw districts that have drawn to favor or disfavor a particular party. And they need to be able to refrain from adding extra criteria that fit their own personal preferences to the detriment of the criteria that are actually in the law. There are lots of advocates out there advocating for district plans to meet a particular measure. And if they cause no detriment to the other things that California says the commission has to apply, great. But if they detract from the things the commission is told to do by the law, that's a liability for the commission itself to pay attention to, or to incorporate, or to apply those other extraneous measures. I think I have time for a short question if there are any, but we are rolling on toward a finish.
I don't see any.
Okay. So I've talked about the criteria that the commission is going to be told to apply. That implies a lot of things that we've talked about before and that you will naturally see. It implies a quantitative capacity. It implies a qualitative capacity. It implies the ability to consider and resolve conflicts, and particularly the ability to reconsider assumptions that people may have coming into the process, particularly in light of the way that path dependence works. Fixating on a particular district and calling it done may mean that you're depriving other districts of opportunities down the road. So the ability to come back and reevaluate, that mental flexibility is important. You also, I suggest, should watch out for natural human tendencies in this process. You can't get rid of them, but you can test whether people can control them. What do I mean by that? Many people prefer clarity to ambiguity. Ambiguity makes many people uncomfortable. And some prefer to spend less mental effort on more ambiguous concepts. But in some instances, the law that the commission is supposed to apply makes ambiguous concepts just as important as clear ones. There is no preference for city or county lines, which are clear, over community lines, which are not. And if you find people who reliably prefer and give weight to the preference of clear rules, then you'll find people who systematically denigrate other really important aspects of the law they're supposed to apply. Facing difficult choices, many people prefer to constrain their own discretion. But in some instances, the law intentionally leaves discretion to further other objectives. Constraining myself to a lower standard of population equality, or a higher threshold to have less population inequality, may unlawfully prevent me from giving weight to other things that the commission is told to consider. And so you'll need to find people who are comfortable with not artificially constraining their own discretion beyond what the law may provide. Most important and hardest to beat, many people have preconceived notions about what a good district looks like. And I am willing to bet that looking at an assortment of districts from various places and various things, that you mentally label some of these districts as good and some of these districts as bad, just as by natural course. And I'm here to tell you that you cannot know whether any of those districts are good districts or bad districts based on the information I've given you. One of those is the city of LA. One of those is Thailand. One of those is the Western Illinois, Western Chicago district that I pointed out earlier. The fact that a district looks regular or looks irregular does not tell you what it's doing or whether it's legally compliant under California law. We had a very tangible instruction in this in the popular world not that long ago, and it's useful to remember. I don't know whether you know this gentleman or not. To me, he looks like a guy who lives in my neighborhood and does not particularly look like a championship heavyweight boxer. And if I show you Mr. Andy Ruiz up against a boxing opponent that he faced not long ago, Anthony Joshua, you might be inclined to think that Mr. Ruiz, in picking this fight, was picking a fight he was most definitely going to lose, because he doesn't fit many people's image of what a boxer looks like. And the betting markets, which are usually somewhat resistant to this, made the same mistake that many people do naturally in giving Mr. Joshua a 97% chance to win. But of course, what a boxer looks like has some connection, but only limited connection, to how effective a boxer he may be. And that image on fight night looked very different to a lot of people. Mr. Ruiz ended up winning this match, surprising a lot of people who were judging him based purely on how he looked. We regularly get surprised by judging people based purely on how they look. The same is true for districts. You cannot know which of these is the better boxer by those pictures. Can't. You cannot know which of these districts is the better district based on the pictures. You can't. The law actually privileges a careful balance of factors rather than an instinctual image, and overcoming that very natural human tendency to say that looks good to me. A figure of speech that can prove really disastrous in this arena is really important and may well be the single most important factor you're screening for. Some people, in addition to all of that, have learned human tendencies. They may have learned what particular redistricting phrases or concepts mean in other arenas where California law points to something very different. And so you may watch out or need to watch out for people importing their own understanding to the exclusion of what the law actually requires, and to the exclusion of what their fellow commissioners prefer. There are differences in California state constitution when they say accomplish an objective to the extent possible and accomplish that thing to the extent practicable. Not all of the commissioners may agree on exactly what that means. They're going to have to come to that understanding, and it's best if they don't import what they think they understand from other jurisdictions and trying to understand best how to effectuate this language. I don't mean to suggest that you should screen out anyone who manifests a preference for clean lines. These preferences are natural. They can be overcome. And I wanted to emphasize that they're not based on technical expertise. It is not technical sophistication that I'm suggesting you should be screening for. In fact, sometimes with the most technical sophistication can also be the most dug in about what they know versus what the law actually requires. What I'm suggesting is that you may be able to screen for individuals' ability to overcome these particularly natural human tendencies through instruction and good faith engagement with the process. I have 5 minutes left before noon. I have 5 minutes left of slides. These tend to be quicker because I know that you'll be thinking about them in other contexts, particularly when some of the commissioners from past cycles come to talk to you, and the continuation of this meeting today, tomorrow, and the next day. The commissioners draw lines, but they do not just draw lines. You're looking for people who will be able to seek training, who will have to know that they need it and then go out and get it. You're looking for people who will be able to hire and supervise staff and counsel and consultants, and to collect the data that they will need to actually draw the lines, and to conduct outreach, and to establish a hearing and public review process to guide the feedback that they get back, and to work with the legislature on particular funding particularities and on access to some of the data they may need, who will need to manage their own budget, who will need to make broad policy decisions and very narrow ones, who will need to produce a report actually describing all that they've done and the reasons for the districts they drew, including terms and standards they may have defined in the process, and who will need to defend litigation. And I say who will need to because litigation in this arena is normally not an if, but a when. And all of those require traits that are similar to, but slightly different from, the traits that I've just suggested in actually applying the constitutional restrictions of redistricting themselves. You'll want people who will be able to work in a team, particularly with people they may not have worked with before. You'll need people who will be able to manage staff and consultants and divvy up responsibilities among themselves without over delegation or without micromanaging. You want your commissioners engaged, but not doing all of the work that supplies their decisions, and not just defaulting to whatever it is their staff or consultants tell them without asking hard questions. And you'll want people who are comfortable with some uncertainty, including the need to start well before all of the data is actually in hand. Why is that important? Because all this happens real fast. The timeline is really short. You all conclude your work at the latest by August 15th of next year. Actually, you all conclude your work significantly before that. The commission themselves are selected. The final 6 commissioners to join the first 8 will be selected and in place by August 15th. That's the final date, the last date by which the commission itself is constituted. That group of 14 people will have to start almost immediately establishing an internal process for how they work with each other. We'll have to learn about the redistricting process to the extent that they don't already know about it. We'll have to hire staff and counsel and consultants and develop a process for hiring staff and counsel and consultants. And we'll have to begin collecting data. And if all of that does not happen or start happening by the end of the year of 2020, the commission is going to be putting itself in a very difficult hole. They have, thankfully, the experience of the commission that went before them. They have the guidance that I know the auditor will give them and that others in the state will give them. They have shoulders of giants to stand on, but they're going to need to start quickly. The census will deliver its results on or before, and probably substantially before, April 1st, 2021. So the data, all of the data that the commissioners will need, with I think the single exception of the data about incarcerated individuals, will be in before April 1st. The commission will have to start before the data is there. Consultants should be gathering data. They should begin taking testimony before that date, because they have 2 months after that date, 3 months. I don't want to take away any more time than they already are constrained in. They'll have 3 months from April 1st to deliver a first draft of maps. And there's a huge amount that has to be done in that time. and then only another month and a half to adjust. If they are lucky, litigation will happen only after the maps are drawn. But they may well have to contend with litigation at some point in the process beforehand. And so you're looking for individuals with all of the traits that I've mentioned who will be able to pull together this incredibly important work, incredibly meaningful work, in rather short order. It's possible. The last commission was a group of exceptionally talented individuals, and I don't say that because they were unique redistricting unicorns. They were a group of people who were exceedingly capable, who had many of the traits I just suggested, and though they stumbled in some places, they endeavored as a team to do what I think was, in the whole, a really exceptional job. You have 21,000 people, at least in the original screen, active and eagerly seeking to serve. I very much hope that that remains a robust pool after the supplemental application. And so I am fully confident that there are 120 and 60 and 14 individuals coming out of that pool that will be able to do all of these tasks. California is a big and really talented state. There are plenty of people who can fit the role. I really thank you for your efforts in getting them there, because as you can see, there's a lot to consider in this process. And the fact that you all are able and willing to engage as seriously and thoroughly as you have is tremendously heartwarming. So finally, I wish you and the eventual commission good luck. I'm more than happy to be available for questions throughout this process, not just today, but ongoing. I want to be a resource to you all and to the eventual commission if I can be. It's now noon, so I deliver you on time, but I'm happy if you have questions before we break. I'm happy to take any of those, or even after the break.